So this is the third video for weeks 3 to 4, and we're going to start out in this video with another screenshot from the textual outline, and that is on page 8 of the textual outline. And let me get back there again. It says, or it's entitled, Intermediate Appellate Courts in New York. There's a heading that was left out, and I'm going to indicate where it should be. It is right after Appellate Divisions of State Supreme Court. There should be, to the margin, Highest Court in New York. And then underneath it would be Court of Appeals. So let me go back up to the top. Intermediate Appellate Courts in New York. We're not going to worry about appellate terms of a Supreme Court in the first and second department because that's downstate. That's not to say that some of you may not end up living there and working there, which would be terrific. I worked in New York City for a while after I got out of law school. It's a pretty interesting place to be. When I came to Buffalo, I thought I was a millionaire, by the way, because the cost of living was so much less expensive here, which is, I suspect, one of the reasons I then never left. But in any event, we're not going to worry about county courts in the third and fourth departments. And the reason I'm saying that, in terms of civil litigation, if we do have an appeal from the city court, town court, or village court in a civil matter, we'll be taking it to the county court. I'm going to suggest that in a hypothetical law firm that does civil litigation in New York, that's going to be a rare instance because we will not be handling very much civil litigation in the city, town, and village courts. Where we're going to have our appellate court action in New York in our hypothetical firm would be Appellate Division of State Supreme Court. And let's just first identify it. The state is divided for purposes of this court into 4 different judicial departments. As I indicate, they're organized by geographical area. And here in Western New York, we are in the 4th Judicial Department. It's headquartered in Rochester. Why not Buffalo? Because Rochester is a more central location for the attorneys in the 4th Department who may be representing clients on appeals. Buffalo would be at the western edge, obviously, of the 4th Judicial Department, which means if we have a morning calendar to make in the 4th Judicial Department in Rochester, we've got to get up early that morning. The appellate divisions hear civil and criminal appeals from the trial courts, and for civil matters, they're going to hear an appeal from State Supreme Court, and that's going to be our primary focus. So if we have, let's say, a personal injury case in State Supreme Court, and there's a need to take an appeal, as there sometimes is, then if we're representing one of the parties, we're going to be taking that appeal and arguing that appeal in the appellate division of State Supreme Court. And if the case is out of Erie County, New York State Supreme Court, then it'll be in the 4th Judicial Department. The other thing I would want to say about the appellate divisions generally, they are the regulatory agency in New York State for licensed attorneys. So if an attorney is the object of a disciplinary proceeding, the regulatory agency that can sanction the lawyer up to and including revoking the lawyer's license, sometimes known as disbarment, would be the appellate division. Now let's take, which we've now identified as the highest court in New York, the New York Court of Appeals. It's headquartered in the state capitol in Albany, New York, and it hears appeals from civil cases and criminal cases throughout the state. And as you might imagine, if you think about this, this one court, by the way, there's 7 judges, and there's a procedure that finds them essentially appointed by the governor. But there is so much traffic going through the New York State court system that the New York Court of Appeals has tremendous power in a way that the United States Supreme Court has to decline to hear cases or give cases full consideration. That court really can pick and choose the cases it wants to hear. But it's the court, sometimes known as the court of last resort. Other states, by the way, call their highest court by different names, including Supreme Court. But in New York, you'll notice that the New York State Supreme Court is the trial court, and the Court of Appeals is the highest court. I want to do one last thing in this screenshot recording, and I've gone to page 13 of the textual outline. So again, this material is in the textual outline and is not set forth in a separate posting. I know some of the material is, but the material in the textual outline sometimes for me is good enough so long as I have a few more words to say. So our final topic in this screenshot video is venue in New York State Supreme Court, and I alluded to that either in this video or the video immediately preceding this video. But venue, which I believe is a Latin term, is the place of trial. And again, remember, we've got 62 counties in New York State, and each one of those counties could be thought of as a place where the New York State Supreme Court, which is a statewide court, does business. And what we have to do if we're starting a case out in New York State Supreme Court on behalf of a party, of a plaintiff, we'll say for now, we have to select a county of venue. I have an aside for federal courts, which we'll talk about more later. We have rules of venue too, but let's just focus on New York State Supreme Court. So as I've indicated in paragraph 2, the party bringing the case has to identify a county of venue, and we get to the primary rules in paragraph 3. And here, please take note because there's an important change that is not reflected in the textual outline, and I'll just make it verbally. And the important changes from the time I prepared the textual outline until today, January 30th, 2021, there's been a change in New York law somewhere along the way. And when the defendant is a non-governmental entity, the county of venue selected in the New York State Supreme Court can be based on the residence of either the plaintiff or defendant, or, and this is the add-on, or the county in which the claim arose. So let's just think this through a little bit, and let's take a car crash. And let's assume what we have is this. A plaintiff who resides in Erie County is going skiing in Ellicottville, which, if we know our counties, is in Cattaraugus County. And a defendant who lives in Niagara Falls is also going skiing in Ellicottville. And so now what we've got is in downtown Ellicottville, a plaintiff who lives in Erie County, a defendant who lives in Niagara County, and they're driving along the streets of downtown Ellicottville. And let's assume one of them blows a stop sign or a red light going rather fast. There is a substantial vehicular accident. such that the person injured suffered what we call in New York State a serious physical injury, meaning there can be a lawsuit brought. And let's assume it's the Niagara County person who was injured and who will be our plaintiff. So when the lawyer representing that Niagara County plaintiff starts the case out in New York State Supreme Court, that lawyer will have three choices of venue: Niagara County, Erie County, and Cattaraugus County. Why? Because Niagara County is one of the counties of residence, Erie County is the other county of residence, and to reflect the new change, Cattaraugus County is the county in which the claim arose. Just a quick note, if a plaintiff's lawyer has a choice of venue, there's going to be strategic factors that will perhaps enter into the play or the decision-making process. And they might not always be available, but let me just give you an historical one. A very good friend of mine is a lawyer, and he practices law in Waterloo, New York, which is in Seneca County. Now, if you've ever been to Seneca County, you will know that it's a very pleasant place, but it's a very rural county. And the thinking has been, and it probably is changing now, but the thinking has been over the years, a jury selected from the residents of a rural county may be far less willing to award a plaintiff a large sum of money than a jury from an urban county. And obviously, there's a lot of guesstimate and et cetera. If, like me, though, you were raised with country people, at least back then, you will know that a lot of them were very tough. And if you ran a farm, my family didn't, but if you ran a farm, Grandpa's limping because the tractor fell over him one year and he got his leg fixed after the harvest came in. So they weren't always, those rural-based juries weren't always perhaps as willing to make a large award as an urban-based jury. And again, there's a lot of other factors. But my friend in Seneca County would always hope that he could find a way to bring his case in either Monroe County, which is where Rochester is, or Onondaga County, where Syracuse is, on the ground that those counties, and he couldn't always do that, those counties were urban-based counties, and his jury would be from that area rather than from the rural counties like Seneca County, or due east of Seneca County is Cayuga County, and due west of Seneca County is where I grew up, Ontario County, and those are all rural counties. So that might factor then, just thinking about the type of jury you want. The last thing I think I would want to say, if we're suing a government, then there's going to be some special rules. Sometimes we've got to sue if it's a state agency in Albany County. Otherwise, it's the county in which the government entity is located. So, for example, I've over the years have represented various school districts, and if you were going to sue one of my school districts, you were going to have to sue them in the county where they were located. Okay, that's going to end our look at venue, and it'll end this video.